I'm Paul Valois. I'm an attorney and I practice in Lynchburg, Virginia. This video is part of a series of videos I produced providing general information about criminal investigations and criminal prosecutions. This isn't legal advice. If you are the subject of a criminal investigation or a criminal prosecution, you need to consult with an attorney where you live to get the advice you need in your particular case. In Virginia, almost all criminal prosecutions begin with the issuance of a warrant. In order to obtain a warrant, the police officer or sometimes another person connected to the case has to swear under oath facts sufficient to issue the warrant, either to a magistrate or a judge. In practice, it's almost always a magistrate. A magistrate is a form of a lower level judge. They used to be called justices of the peace. Now they're called magistrates. The magistrate will hear the facts sworn under oath, sometimes in writing, sometimes verbally by the police officer or by the complaining witness. And if the magistrate decides that facts are sufficient, the magistrate will issue the warrant. Once the warrant's issued, it'll be served on you. If you're not already in custody, you'll actually be taken into custody, taken to the police station or the sheriff's department and booked. At that point, you're formally arrested. Once you've been arrested, you will be given a bail determination, usually by a magistrate. Most people receive bail. Not all people. If your crime is serious or if you have a really bad record or both, you could actually be denied bail and you could end up having to spend the whole period before trial incarcerated in jail. But most people get bail. Once you're issued bail, you have to understand that you're under the conditions of bail. Bail is more than just posting bond if it's secured. There are certain other conditions, and there's some real common ones that seem to be common to most cases. First of all, is the general good behavior term. You can't pick up any new charges, and you can't get in any trouble while you're on bail. If you do, then you could lose your bail. It's very common in Virginia to see requirements, and living in Lynchburg, close to the North Carolina border, as we do, this can be a problem sometimes. There's a requirement that you can't leave the Commonwealth of Virginia. A lot of people here actually travel to North Carolina and further south, a little further south from here, it's not uncommon to see people who live in Virginia but whose jobs are in North Carolina. So these are conditions you need to think about when you look at your bail determination. There are other conditions. Abstain from the use of alcohol is a common condition. Refrain from possession of firearms, especially in hunting season. This can be a problem. So make sure you pay attention to the bail conditions, and you don't want to violate those, or you could end up having your bail revoked and spend that time in jail pre-trial. If you're arrested on a misdemeanor charge, your case will be tried in the district courts, right? And that's pretty much the end of the process. If you're arrested on a felony warrant, there's an intermediate process. A thing called a preliminary hearing will take place. And that's a hearing in the district courts, the lower level courts, first, by a judge, who just checks to make sure that there's enough evidence to find probable cause to send the case to a grand jury to consider. It's an extra step in the process. If you're arrested on a warrant, you'll have a preliminary hearing if you're charged with a felony, almost always. These hearings can be waived, and it's common to see the prosecution null pros, or temporarily dismiss the charge to avoid having a preliminary hearing, but usually you'll have a preliminary hearing. After the preliminary hearing, the judge can at the preliminary hearing, the judge can decide one of three things. The judge can decide there's not enough evidence for the case to go to a grand jury, and he can dismiss the warrant. This is usually not a good news in a serious case, because it doesn't stop the prosecution from bringing the case back. Because you haven't been tried yet, the double jeopardy prohibition in the Constitution doesn't apply, and there's nothing stopping the Commonwealth or the prosecutor from bringing that case directly to a grand jury and having you indicted by a grand jury directly later. If the judge decides there is sufficient evidence, he can certify, well, the judge, he or she can certify the case to a grand jury. And then the grand jury will hear the evidence, and based upon the Commonwealth's evidence, they only get one side. They just get the Commonwealth's evidence at this point. They can issue a bill of indictment. And that's the formal charge in the circuit court of the crime. And that's where you'll be tried, in the circuit court, for a felony charge. The third thing that the district court judge can do at a preliminary hearing is decide that there's not enough evidence to charge you with a felony, but that there is enough evidence to charge you with a misdemeanor. If the district court judge makes that determination, then he can switch the case from a felony case to a misdemeanor case, and you can be tried in the district court on the misdemeanor, usually on the same day. It's not common for that to happen, but it does happen, and if it does, it's usually a good thing. It's usually a good thing to go ahead and have the charge reduced on the spot by a district court judge. So, after an indictment is issued, assuming that an indictment is issued by the grand jury, the case will be set for trial in the circuit court. And at this point, you will have the right to decide whether you want to have a jury trial or a bench trial. Understand that in Virginia, you're not the only one who can demand a jury trial. The prosecutor can also demand a jury trial, and the judge can demand a jury trial. So you may end up with a jury trial whether you want one or not. But if you absolutely are entitled to a jury trial if you demand. At trial, you'll either be convicted or acquitted of the charge. If you're convicted of the charge in the circuit court, then you can consider whether or not you want to appeal. If you're convicted of a charge in the district court, you actually have the automatic right to appeal that charge to the circuit court. However, if you're convicted in the circuit court, you have the right to petition for appeal, but you don't have an automatic right of appeal to the Court of Appeals in Richmond. I hope this information has proven helpful. If it has, check out some of the other videos I posted on the website. My wife, Margaret, practices in bankruptcy primarily, and she's posted some other information on our website and some videos. This is something you need to hear about, and unfortunately a lot of people do in this bad economy. Go ahead and click on one of those and get the information you need to make the right decision. Thank you.